Keep Our Republic is a nonpartisan, nonprofit organization. Since the spring of 2020, we've been doing our part to help keep our republic. We do it through hyper-localized civic education. We talk with Americans through town halls, legal seminars, media briefings, and other events. We know a lot of Americans have a lot of questions right now about how our democracy really works. Questions like, what actually happens behind the scenes on election night, and just what is the power of the federal courts? That's why we're talking directly to election officials and judges from across the country. Together, we can help answer some of those questions. Welcome back, everyone, to Keepers of Our Republic. If you're new here, this is a weekly nonpartisan podcast. We are talking with election administrators and with legal experts about supporting the rule of law and our democratic institutions. If you don't already, I want to ask you to make sure to please subscribe or follow us on YouTube, Spotify, Apple Podcasts, all the normal places where you may be listening to your favorite podcasts so we can have a conversation with you on these important topics every week. Today we are discussing an op-ed that was published last week in the New York Times that speaks to a subject that has weighed heavily on us in the legal profession for some time now. The article is titled, "A Simple Proposal for the Legal Profession to Regain Its Dignity." If you haven't read it yet, I'm going to link it in the show notes for you, as well as some of the other items we'll be discussing today. In short, in January of 2026, Keep Our Republic and our partners issued an open letter calling on lawyers, law firms, and legal organizations to stand up for the rule of law by endorsing a baseline set of principles for the independence of the legal profession. This set of principles is authored by more than 30 former federal judges appointed by presidents of both parties. And the release of the principles marks the launch of a national effort to ensure that the legal profession remains a central pillar of a flourishing republic governed by the rule of law. To that end, we have two distinguished judges who penned an opinion essay in the New York Times to discuss the principles and the need for a coordinated response to recent attacks on the legal profession. With me today is one of the authors of that opinion piece and a member of Keep Our Republic's Article 3 Coalition, Judge Schendlin, former judge of the U.S. District Court for the Southern District of New York. And with her is Deborah Pearlstein, who is the director of the Princeton Program in Law and Public Policy. Thank you so much both for joining me today.
Thanks for having us.
So I wanted to start off with a little bit of background. If one of you could lay the groundwork for us. Many of us in the legal profession have been following these developments, but I'm sure there's someone who is listening or watching who maybe doesn't understand sort of how we got to where we're at and what we're talking about in terms of these attacks and these threats to the legal profession. So sort of what is the genesis of how we got to this moment?
So I think I'll take that. About a year ago or so, this new administration came into office. And they issued a number of executive orders. That means that from the president, the executive, issued orders to a number of law firms. And those law firms were not selected at random. Those were law firms that the administration sort of had a dispute with because of the fact that partners at that firm had represented individuals or issues that this particular administration didn't like. And so he issued executive orders to those law firms and made certain demands and made certain threats. And the law firms who received those letters were concerned about the economic impact on their firm if they didn't sort of adhere to the demands set forth in the letters. And the threats were very serious. The threats in these letters were such as we'll pull your security clearances, we'll be sure that your clients lose certain funding, may not get grants any longer. So we're threatening your clients, we're threatening your firm, we're threatening your ability to appear in federal court. And some of the firms that received those executive orders were so concerned that they sort of rushed to the White House to try to negotiate a resolution. And they, to put it in blunt terms, they made deals. They made an agreement with the government going forward. And those agreements committed them to not doing certain things and to doing certain things. So they agreed to provide pro bono, which really to them just meant free legal services to the government for the causes that this administration wanted counsel to represent. And they agreed to do that at no charge, hundreds and hundreds of hours. I don't like using the word pro bono because pro bono should mean pro bono publico, which means in the public interest. This really isn't pro bono. It really is for free. We will do what the government asks us to do. So they made that agreement. And in return for that agreement and to not represent certain clients or certain causes, not to sue the government withdrew its threats that I had described earlier. Other firms didn't make an agreement. They challenged the constitutionality of these executive orders in courts around the country, saying these orders violate our constitutional right, our First Amendment right to free speech, right? To say and do what we believe we should be doing. And each time a challenge was mounted, those firms were victorious. 4 different district courts around the country agreed with those firms and said, these orders are blatantly unconstitutional because they violate the First Amendment. Now, those orders are on appeal now, and we don't know what the appellate courts are going to do. But so far, the firms that resisted these orders have been successful. The firms that made deals, so to speak, have been criticized by bar associations and other organizations around the country. So that's a longer answer than I'd like, but it tells you how we got here today.
So now that we have the background, let's talk about the principles. And I guess I'm also asking for background on this. Maybe Deborah could speak on it. Who came up with the idea to bring about this set of principles that we're going to talk about a little bit later here?
So great. And thanks very much for having me. If I could, I just wanted to add to the judge's wonderful description of sort of how we got here, put a slightly finer point on what we're seeing, because in part it leads to why I became so interested in this question. The fall off in firm representation we're seeing is absolutely, as the judge said, in pro bono services available to any number of organizations that have commonly sought pro bono services from law firms. But that's not the only fall off we're seeing. We're also now able to start seeing just a reduction in pleadings filed against the government on behalf of paid clients of these firms as well, which is really striking and suggests an enormous chilling effect on so-called big law, these large law firms that were targeted by the administration, not just in whose cases they take on, and every lawyer has an obligation to do pro bono work as part of their licensure as a lawyer, right? Not just their willingness to take on clients and causes who themselves are averse to the administration, but to zealously represent the clients that they have and have long represented, mostly from the corporate world as well. So that's another sort of, I think, critical piece of the impact that we're seeing. How these particular principles came about, so I'm a professor and a researcher, and I'm worried about, I've long been a professor of constitutional law, deeply worried about the impact of what the administration is doing on constitutional democracy writ large. And this is sort of the other piece about talking about the impact and why the attack on law firms in particular matters so much. So there are 2 tactics that we've seen from the current administration that are familiar to sort of autocratic or democratic backsliding countries around the world that are in play when it comes to the administration's targeting of law firms, right? One is would-be autocrats go after civil society organizations that have independent power to target them. So law firms are to challenge the legality or the legitimacy of what they're doing. So law firms, just like universities, just like the independent media, just like other organizations, NGOs, and so forth, were among the groups initially targeted by the administration to try to achieve this chilling effect. If you chill these independent actors, right, there are less potential challenges that the executive has to face, makes it easier for them to consolidate, to attain and consolidate the power that they have. So that's one piece of the strategy. And the second piece is, and here the law firms were an incredibly important early test case to demonstrate that law doesn't matter. The rule of law doesn't matter as much as what kind of deal you can make with the executive or with the would-be autocratic ruler, right? So even though it was very clear, as 4 different courts have now said, that the executive orders that the president issued were illegal, clearly illegal, right? They did it anyway, and the firms that could have challenged struck deals, right? And the impact of that is to create this really powerful and troubling normalizing effect of making deals even when the law is on your side, right? And that has helped ease the way or pave the way toward this public corruption on a rampant scale we're seeing now, where private actors across the country and around the world realize we don't necessarily need to follow the law. We just need to make a deal, and everything is essentially negotiable, right? That's not a country operating under the rule of law. That's operating under the rule of man, and that's completely inconsistent with what we do as lawyers and certainly as judges as well. Okay, so that's the perspective, sort of from the constitutional democracy perspective, why I was interested in this. And I started hosting, and we have the enormous good fortune here at Princeton to be able to host meetings, to invite folks, not just other scholars, but people who are law firm partners, people who are working at corporate general counsels, people who are, staffers in Capitol Hill, lots of other people who work for NGOs and groups that need pro bono services, and many others, to begin to talk with them about what's happening and critically, what, if anything, might be done about it. And here, the perspectives that we had at this series of meetings was fascinating. And there were suggestions kind of across the board. But one of the very consistent themes we heard, not only from scholars and democracy scholars and people who study these in other countries, this kind of sort of strategy play out in other countries, but current law firm partners, law professors, law school deans, and so forth, was the idea that it would be helpful, without demanding the firms who had made deals retract those deals, right, which seemed unlikely to happen in the near term. What would be helpful would be to have a common set of principles that were short, and as the judge can talk about, they're modeled after tools that have been used in the past, to try to make an affirmative statement about the independence of the legal profession and the willingness and the commitment of members of the legal profession to stand by their obligations as lawyers to zealously defend their clients, among other things. So we can talk more about the details of the principles, but the idea of it and the strategy, and we can talk, if you like, about the reason why so many different groups thought that would be a useful tool to have, came out of those meetings through really a sort of diverse, certainly bipartisan group of participants.
I do want to jump into some of these principles themselves because they're very interesting. And like you said, there's nothing incredibly new or novel, and yet somehow these are so very important for us to state with some clarity as a legal profession. So I'm going to jump into each of them. We kind of have a brief conversation. The first of the principles, and I'm going to paraphrase, but if I misstate, please let me know, is to a commitment to defending our constitutional right to be free from government coercion or retaliation for activities that are protected by the First Amendment. We've talked on this podcast a lot about judges getting their First Amendment right, so to speak, back once they have retired. But first, we have a First Amendment for attorneys in the legal field. We exercise it in some really specific ways. So I wonder if either of you wanted to talk about this first principle and sort of the importance of protecting our First Amendment rights in the legal profession.
Well, this goes back to what we said at the beginning of this podcast about targeting firms for a particular reason. So, for example, if a partner at the firm had been part of the Mueller investigation, now the whole firm was targeted because this government didn't like the fact that that partner was at that firm, or because a firm represented a certain other client on a certain issue. So it would be somebody that a lawyer at the firm took a case they didn't like, or an issue they didn't like, or sued the government on an issue they didn't like. And that's the point, that the government should not be interfering with the lawyer's responsibility to represent their clients without fear and intimidation that the government will somehow punish them for representing their clients as best they can. So that's the point of that first principle, is that lawyers need to be able to act without fear.
Yeah.
And they have a right to speak. And it's very troubling to think that our government tries to shut down their ability to do their jobs. So I think that's why it's the first principle, and it's a very, very important principle.
And I should say that the language of that principle, a chunk of the language of that principle, flows directly from, in fact, to some extent, quotes, I think, some of the judicial opinions that were issued saying, law firms have a First Amendment right to choose what clients they represent and to speak on their clients' behalf, right? And to donate to what causes they want to donate. And the government sanctioning them for the exercise of that First Amendment right is not only clearly unconstitutional, right? The principle says lawyers should stand up for that right. Right? It should be an uncontroversial proposition. And here, the firms that decided to negotiate with the administration, and it was an extraordinary time. It remains an extraordinary time. They faced and felt as though they faced extraordinary pressures and still do, right? Here, it's not requiring, signing on to the principles doesn't require them to do anything different, but it is a way for firms to message to the law students they're trying to recruit, to the companies they want to represent and do business with, to potential clients down the road, to existing clients, that they will in fact be defenders of the legal rights that are available. And I think that's part of what makes the value of these principles so strong, sort of for firms across the board.
Yeah. And the second is obviously quite related, but I'm sort of summing this up as reaffirming not just our right, but our obligation as attorneys to be zealous advocates for our clients, which can include our duty when necessary, I'm quoting now, to challenge official actions. Talk about the importance of sort of reasserting this obligation we have in the legal profession.
Well, the second principle does reference the rules of professional conduct. So that's why I say it's not controversial.
Yeah.
We're not really breaking new ground. We're emphasizing to the public and to the profession that as members of the legal profession, we have a duty to represent clients. And we are officers of the court, is a phrase that's used, officers of the court, which means you have an ethical and sort of moral obligation to represent people without fear. And that's the important part there. And so when we say without fear, it means that you may have to sue people in the government from time to time because you're challenging a policy of the government that you strongly think is inappropriate. Either it's unconstitutional or it's just discriminatory in some way. It targets certain groups over other groups. Whatever it does, there's a need to challenge it. And that's what lawyers do, and they do it bravely. And as the professor pointed out, that can be for your corporate clients too. They could be challenging a particular regulation or the way that regulation was developed, that there wasn't an evidentiary record, it wasn't done right, whatever it is. You have to be free to bring those challenges. And that's a good thing. That makes our country a better country when you can raise issues like that and have courts resolve issues like that. I've often said, courts can't decide what issues to address. They can only address the cases that come to them. So if there's nobody willing to challenge a policy, well, then there's no opinion from a court saying that the policy is illegal. And so we become a better country because of our legal system and because we are built on the rule of law. If all the lawyers are scared and they don't bring the challenges, then we have a society that becomes beholden to the one autocratic leader. And that's a very dangerous thing. That's not what a democracy is, and that's not what a country is that's built on the rule of law. So all of this has really got a lot of background to it beyond the words, the short words of that second principle. Beyond that, what it really means is we need lawyers, and we need lawyers to be free to do what they do best.
It's so interesting. This principle specifically references the rules of professional conduct, and so many of our modern ethics rules that have been adopted statewide, the model rules of professional conduct, I'm sure we all recall, came out in large part because of a different president. And in some of the aftermath of the Watergate scandal, there was calls for reform for the legal profession and to reassert and to reposition the legal profession as one that follows and adheres and champions the rule of law. And so I enjoyed that symmetry of bringing in this idea that this is not a new concept, that the legal profession needs to assert itself as a professional, ethical body. It's just we got to do it with a different set of principles now. All right, moving on to the third, shortly, a duty or an obligation to uphold our duty as members of the legal profession to provide legal services to those unable to pay. Judge, you talked a lot about pro bono a few minutes ago at the open of this podcast. Talk a little bit more about true pro bono work and why that is so essential for what we're talking about here today.
There are people in our society who have been targeted in many ways or have been unable to be equal to other citizens. And that's not right. And they need representation more than anyone else, whether it was those who suffered from poverty or from lack of education opportunities or equal job opportunities, whatever it was. There are segments of our society that historically basically have been oppressed, and they need representation and generally can't afford it. They aren't wealthy, they aren't corporations. And so the legal community has always been very good about stepping up and representing those people who need them. And I should have mentioned also voters. I missed that by not referring to voters, because voters is everybody, rich, poor, and in between. Those and new citizens, those are voters. And sometimes there's an interference with voting rights. And so that's another group that has very much needed the representation of lawyers. And that's often done pro bono, means in the public interest, to make sure that everybody who wants to vote can vote. Because there's a history in this country, going way back, of voter suppression. And after the Civil War, there was an effort to make sure that Blacks weren't able to vote in the South. And eventually, after many decades, they got the ability to vote. And now we're seeing some problems with redistricting that again seems to be taking away people's rights to vote or to equally vote for the candidate of their choice. And we're seeing pressure put on the voting system, cutting voting hours, cutting voting places. There's lots going on in the voting area, so I'm glad I remembered to raise that. But my point is, these are issues of public concern, and no one is better placed to help enforce the rights of all our citizens than lawyers. And I shouldn't stop at the word citizens, because we're seeing a lot of issues in the immigration area now where immigrants, legal immigrants, but not yet citizens, are being targeted, and they need lawyers. And lawyers have tried to be very active in protecting the rights of those people also. So I'll stop now because I'm sure the professor wants to add some good thoughts here, but those are some of my thoughts.
Yeah, jump on in, Professor, because there's so much to unpack with this particular principle.
There really is. There's no question that the rules of professional conduct, right, require licensed lawyers to provide pro bono services, a certain number of pro bono hours per year, right? And law firms have historically proudly done this. Lawyers at law firms have proudly done this. And indeed, it becomes their pro bono successes, their successes in these cases, many of which were on behalf of immigrants or people seeking political asylum, or the marginalized, the discriminated against, the poor, the people unable to afford good legal services otherwise, have become a major selling point. Recruiting new lawyers to come work for the firm. If you're a young lawyer just graduating law school, you want to be able to work on these cases, in part because for many people, this is why you go into law in the first place, but it also gives you, as a young lawyer, tremendous opportunity to actually get into a hearing room or get into a courtroom or actually do the work that you were trained to do. So it has become a huge fraction of legal services in this country are provided free by to those who can't afford them, have been provided by major law firms, hundreds of millions of dollars worth of legal services. Here, what we're seeing is not only a pullback from the provision of services against groups that have traditionally represented, for example, those seeking political asylum or those seeking to assert voting rights or election protection raising election protection sorts of concerns, or many other areas, right? We're also seeing the firms promise, we have seen through these deals, the firms promise to take on cases that serve interests that the government says. Now, some of the interests that the administration has said they're interested in serving also would count as these disadvantaged groups, right? Take on pro bono cases representing, for example, veterans or those who need access to legal services in some ways. Those would certainly count as exactly the kind of traditional pro bono representation that the bar licensure requires and that firms have historically done to enormous effect in this country. But in fact, the reports we're beginning to get out suggest that some of the work that these firms are doing are in fact work for the government itself, for the Department of Commerce, for example, right? That literally doesn't count as pro bono service in the sense that it was designed, and in the sense that the rules that we're required to abide by mandate, and that it is those unable to pay. The government is certainly an incredibly important client, but it is exquisitely able to not only pay for, but attract the best attorneys in the world,
Yeah.
right? This is not about actually serving the public interest in any general sense. It's, again, it appears to be about serving a particular individual's or particular government's interest, which is rather the opposite of what the bar obligation is meant
Right.
to do. So it's not just the loss of services, it's this real lack of transparency and then growing concerns from public reports that in fact the firms that have made deals are not providing pro bono services in any traditional sense.
Right.
They're rather simply going to work for the government.
Right. I'd be curious to know, have we seen any pushback, Professor, particularly from students who maybe are reconsidering where they're going to do their 2L summer, where they're going to be doing their on-campus recruiting as a result of this deal for quote unquote pro bono services?
Absolutely. And that's been a really striking feature of the sort of near year we've had now since the executive orders were released. We saw at a number of law schools students spontaneously organizing themselves. One of the most striking examples was at Georgetown, which has a wonderful law school, where the students got together and created a database, a spreadsheet that tracked whether whether major firms that students were interviewing in, right? These firms recruit on campus or they recruit law schools from these schools all the time, law students, I should say. Which firms made deals, which firms sued and tried to push back, which firms were targeted. But to be clear, if you take sort of the top 100 firms in the United States, the vast majority of those firms, the vast majority, have simply kept their heads down, right? They're trying not to attract the administration's ire. Now, that's part of why we've seen such a fall off in the availability of pro bono services that might be or even become plausibly adverse to the administration. But it brings me back to the justification or part of the strategy behind the principles that folks talked about in these meetings, which is this gives those firms something affirmative to say. It doesn't put them directly in conflict with the administration necessarily, but it makes it possible not only for these firms, but for students who want to know, and we are seeing a lot of students who want to know, to ask a very specific question of firms they're thinking of going to work with. Namely, gosh, have you signed on to the principles for the independence of the legal profession or have you not? And if not, why? Right? The students are in this universe, the recruiting market. They have collectively an enormous amount of power and influence over law firms, again, if exercised collectively. And even the task of asking that simple question, right, requires lawyers in these firms, the firms themselves, to think about what they're really selling, what they're trying to base their recruiting on, and what kind of firm they really want to be and want to be seen as.
Yeah. I know we're running a little short on time, but I just want to jump through these last three somewhat quickly here because they are still very important. The fourth principle is to kind of briefly summarize. Being mindful of and asserting a right to ensure access to justice to quote all who seek our counsel and in maintaining public confidence in the actual and perceived integrity of the legal process. And it's that last part of the rule or the principle there that I find so interesting and moving. But talk to us about what this damage has been to either the actual integrity of the legal profession, but of course the perceived integrity. And that's something we've talked a lot about in this podcast in terms of attacks on the rule of law, attacks on judicial independence, and the perceived erosion of public trust in that institution there too.
So I think that's a very important question. And I agree with you that the focus is on the last word of maintaining public confidence in the actual and perceived integrity of the legal process. You know, this administration has attacked the judiciary a lot and has called judges corrupt and radical and crazy and loony and all kinds of words to describe judges. And that's a terrible thing because the public loses confidence in the judiciary as a fair and neutral and equal branch of government that upholds the rule of law. So you might say, well, you're talking now about judges. Can you come back to talking about lawyers? And of course, I'll come back to that right now. If the lawyers are perceived also as part of a corrupt system, then the public says, yeah, well, these judges, these lawyers, they're all a bunch of loonies or crazies. And that's just not the case. Not the case. As you know, the Article 3 coalition is completely bipartisan and nonpartisan, meaning it's really not partisan at all, but it's bipartisan in the sense that its membership is almost 50% appointed judges who were appointed by a Republican president, 50% appointed by a Democratic president. How could they be in the room together? Because they all believe in the rule of law. They really deeply believe in our democracy, and that's what keeps our republic, to get back to our name, together, is that we share a common belief in the principles on which this country was founded. So it's very important that the public comes along and understands that the legal profession, which answers to the judiciary, and the judiciary as a co-equal branch of government with the executive and the legislative branch, is what maintains our democracy, because we are a country of laws and not of men. So that's the point, that public confidence in the system is critically important. If the public doesn't believe in us anymore, then it's going to go along with whatever the leader decides to do, whether it adheres to our Constitution or not. And then we'll fail as a democracy. We will decline and fail. And that's a very, very scary concern, I think, to all the members of the Article 3 coalition. So that's why those words are so important, and that's why they're in the principle.
So well said, Judge. Deborah, anything to add on that before we move on?
I will stand on the judge's point there. I thought that was very well said.
So the last two, just very briefly, before we talk about sort of where does the Article 3 coalition go from here? Where do these principles go from here? Sort of tie into these last two. The fifth principle is encourage the application of these principles by those we represent, be they, as we've talked about here today, individuals, businesses, and of course, federal and state governments, we would hope would ultimately come on board. And the sixth is to refuse to accept any representation where a condition of such representation would violate these principles. So what is the goal, I guess, taking a 30,000-foot view of these principles for a second? What is the goal moving forward? I know we're getting people to sign on. I know that this is going to continue to be building momentum between the time we're recording right now and by the time this comes up. I know we're going to have more signatures on this. But how do we encourage these principles to be most widely adopted by the legal profession?
So,
Deborah, do you want
to? Sure, I can give a try. I've learned an enormous amount from the folks at Keep Our Republic and from the judges as well, especially Judge Schendlin, in working on this and sort of advising on this project or consulting. I think the goal is sort of sequence, right? The first is to make folks aware of the principles, and particularly in two populations. One, I mentioned law students, and the other I mentioned were clients. So corporate general counsel, the people who decide which firms they're going to give their business to, right? This gives them a tool to raise the question with the firms they're potentially going to hire. Do you adhere to these principles or not? And if not, why not? They require you to abide by the rules of professional conduct. Do you not do that? Do I want an attorney who is not willing to zealously represent my interests and not other interests in that representation? So it gives those two customers of big law firms, if you will, a tool to try to understand where those law firms fit. And it gives that market, both sides of that market, an opportunity to help engage law firms in thinking about how to posture themselves in this moment of admittedly enormous stress, where the easiest path is to stay silent and do nothing. It makes it easier for there to be collective action among law firms, or at least that's the idea, in embracing these as opposed to striking deals or anything else. It also gives us, I think, going forward, and again, speaking more from a professorial point of view now, a metric, a way of tracking over time how the United States is doing, how the US legal profession is doing, or the part of the legal profession that is big law or even not big law, right? Public interest organizations, state governments, and so forth. Tracking how they're doing from a rule of law point of view, right? These principles aren't just existing rules of our profession, which they largely are. They're also sort of way of measuring whether a country and its legal system is maintaining the basic norms that it needs to adhere to a rule of law system, right? It helps us over time to measure that, and where we're not finding that, to apply pressure to make changes, regulatory or otherwise, penal changes, right? There are a host of potential options where that's not happening, to say, I don't think the system is robust enough. I think we need to change this bar rule. We think we need to change this disciplinary system, right? So lawyers are adhering to these rules. We think we need to have different rules in the state of New York, right? For example. So there are lots of things that this information, that the principles will help tell us about the relative health of our constitutional democracy.
For those big law attorneys who are listening or watching this right now, what message do you have for them that you would like to take away? And apart from, hey, go to the website in the link I'll have in the show notes and sign the principles, what takeaway would you like them to have in this moment?
That's a great and really important question. And yes, go to the link. And there are all kinds of ways to see what the judges have put together and to engage in that important work. I think one of the things that was so striking and so sad about the behavior in law firms that we saw following the executive orders and in the year that's followed is that large majorities of lawyers within these firms are also deeply troubled by what's happening. They're deeply troubled by the attacks the firms have sustained, the attacks that lawyers and judges have sustained. They're deeply troubled by the responses of firms and the change in their behavior in response to the administration attacks. And they're looking for something to do. And some of them, even at the marketing level, right, are looking for a way to demonstrate that they are, in fact, the firms that we thought they were, right? I think this is an incredibly important tool and an incredibly important moment to join together to do that. It was really hard, right? Understandably hard. It's sort of, in an academic sense, a classic collective action problem. If one firm sticks their neck out, right, they risk having it chopped off. But if 100 firms stick their neck out, everybody will be fine. Nobody has the incentive to be that first actor, right? This isn't asking them to sue the government. It's not asking them to strike a deal or not strike a deal with the government. It's asking them to merely restate the principles that they signed up for when they took the attorney's oath, right? It's an opportunity for their firm and for them to be a part of the legal profession that is so critical in sustaining the rule of law and constitutional democracy. That's the pitch I'd make. I'm happy to make it personally, but I think the judges are probably in a better position to do it even more effectively than I.
So I would echo a lot of that, but say it in very short phrase. You are not alone. We've got your back. And I think it's important. It gives people courage. It gives people courage to know that there are so many others that they're joining with to stand up and say, the rule of law is important to me. It's the foundation of our democracy, and I'm not going to let it crumble. So that's the message I would give. This gives you cover. We're united. It's growing by the minute. There are all these signatories, and you should have the courage to stand up, because you and your colleagues have a very important role in our society, and we don't want you to be afraid to exercise that important role. So I think that's the message. This gives you cover, gives you courage.
Well said. Well, we live in a time, in a world that very much wants us to feel alienated from each other. I think this does a wonderful job, as you both said, of bringing together a community and giving cover and giving an opportunity for individual attorneys, firms, organizations to stand up and have an I am Spartacus moment of their own, to be slightly flip about it. Judge, Professor, thank you so much for joining us, for the work you have done on this incredibly important issue, the work you've both continued to do for Keep Our Republic and the Article 3 Coalition, and taking so much time out of your day to speak with us. It's been a pleasure to speak with you today.
Thank you.
Thank you so much.
If you like this episode, please share it on social media and tell your friends. It's the best way for folks to find out about us. I hope you'll agree that our guest is indeed a keeper of the Republic. If you want to learn more about how you can help keep our Republic, stop on over to our website, keepourrepublic.org.